Hello, friends. Good evening. We've covered a lot of topics so far. So, before we start our discussion for today, I would like to do a quick recap of whatever we have discussed so far. Okay. So, let's start. We started our discussion with the offer series, and then we discussed acceptance. Okay. So, the first thing that we talked about was definition of an offer, and we said that when one party makes a promise to do or not to do something with the objective of, with the goal of obtaining the other party's acceptance. Okay, that is when you say that an offer has been made. Okay, and the party who makes an offer is known as offeror. Acceptance definition: when the offer is accepted, it becomes acceptance. The party who receives an offer is known as offeree. Second, what are the requirements of an offer? Number A, offer has to be clear and definite. If I tell you that I want to sell my black car to you, question is that offer clear and definite? Suppose I have three black cars. Now, when you analyze this offer, you would look at two things. Number one, there is no clarity with respect to which black car does this guy want to sell. Second, I have not mentioned the price. Therefore, my offer is neither clear nor definite. And the requirement of an offer is that it has to be clear and definite. If an offer is not clear or definite, then it is not a valid offer. Second requirement is offer must be communicated by the offerer or the offerer's authorized person to the offeree. If you want to offer something to somebody, then you will have to communicate your offer to that person. You cannot keep it in your mind. If you want to sell your pen to somebody else, you will have to communicate that offer to that person. Okay, so that is the second requirement of an offer. Third, an offer cannot contain terms where silence or non compliance is presumed as acceptance. So if you make an offer to somebody and you say that if I don't hear from you in 2 days, I will presume that you have accepted my offer. This is not a valid offer when you make statements like this. Okay, so an offer cannot contain terms where you impose a burden of refusal on the offeree. Okay, now let's look at the requirements for acceptance. Number one, it has to be absolute and unqualified. Okay, we discussed this in detail that an acceptance should accept all the terms of the offer without changing any term of the offer. If any term of the offer is changed or any condition is introduced by the offeree, it becomes a counter offer. Okay, so an acceptance should be absolute and without any condition. Okay, that was the first requirement. Second, acceptance should be communicated, and we had seen to whom. Acceptance should be communicated to the offerer or the authorized person of the offerer. Authorized person of the offerer. All right. And second, by whom should the acceptance be communicated? By the offeree. Third requirement, acceptance should be communicated in the prescribed mode. If the offerer has prescribed a particular mode for acceptance, the offeree should communicate his or her acceptance in that mode only. However, we had seen one condition. Just because an acceptance is not communicated in the prescribed mode, it does not automatically become invalid. So just because an acceptance is not communicated in the prescribed mode, it does not automatically become invalid. And we had further discussed that the burden is on the offerer to object, saying that he wants the acceptance in the prescribed mode only. If the offerer does not object within a reasonable time, so the burden is on the offerer to object in a reasonable time. If he does not object in a reasonable time, then acceptance, even if it is given in a different mode, it becomes a valid acceptance. All right, so these are the basic things that you should remember with respect to offer and acceptance based on our discussion so far. We also discussed the postal rule of communication and instantaneous communication mode rule. Okay, and a couple of things to note. Number one, in a postal rule, in postal communications, acceptance is complete the moment it is posted. Which means that an agreement is formed vis-a-vis the offerer, the moment the offeree posts his acceptance. So we had looked at this scenario with the help of examples. If you remember the NLSIU example that we had seen, NLSIU makes an offer by post to you. You communicate your acceptance by sending a return post to NLSIU. The moment you posted your acceptance letter in the post office, your acceptance is complete and NLSIU becomes bound by your acceptance. They cannot change or cancel their offer now. But you become bound only when your acceptance reaches NLSIU. So an agreement is formed vis-a-vis the offeree only when the acceptance reaches the offerer. So we had looked at both the elements, and this is a strange rule because it tells you that an agreement is formed vis-a-vis one party at one point of time, but with respect to the other party, the agreement is concluded at a different point of time. So with respect to the offerer, the agreement is complete the moment acceptance is posted, but with respect to the offeree, the agreement is complete only when the acceptance reaches the offerer. Now coming to instantaneous mode, when there is no time gap, we had seen that acceptance is complete when it reaches the offeree. In other words, agreement is concluded only when the acceptance reaches the offerer. Sorry, here it will be offerer. Acceptance is complete when it reaches the offerer. Okay, so remember the email example. NLSIU makes you an offer by email. Emails are emails are an example of instantaneous mode of communication when there is no time gap between when you received the offer and when you communicated your acceptance. So in that case, whenever we are talking about instantaneous mode of communication, acceptance by the offeree is complete only when that acceptance reaches the offerer. Your acceptance has to reach the offerer. Only then it will be called a valid acceptance, which means that the agreement will be complete only when your acceptance has reached the offerer. Because for an agreement, you would know, we need both offer and acceptance. When do we have acceptance in instantaneous mode? When the acceptance reaches the offerer. Therefore, agreement is complete when your acceptance reaches the offerer. Okay. And the second thing to note down here is, with respect to postal rule, place of agreement where acceptance is posted. Okay, wherever the offeree posts the acceptance, that becomes the place of agreement. With respect to instantaneous mode, place of agreement is where the offerer receives the acceptance. Okay, again NLSIU example. When NLSIU made you an offer by post, NLSIU is based out of Bangalore. You received the offer in Delhi. You are based out of Delhi, and you communicated your acceptance by sending a return post from Delhi. So in that case, the place of agreement is Delhi, because Delhi is where the acceptance has been posted. In email example, which is an instantaneous mode of communication, NLSIU makes you an offer by email from Bangalore. You send a return email from Delhi, where you live. Place of agreement is Bangalore because your acceptance has been received by the offerer at Bangalore. Okay. Third, revocation of acceptance. We had seen that in the postal rule, since there is a time gap between the communications and the offeree is bound only when his acceptance reaches the offerer, therefore, offeree has a unique chance of revoking his acceptance. But revocation should reach faster than acceptance. It basically means that before your acceptance reaches the offerer, your revocation should reach. And in that context, we had seen that if you posted your acceptance on 14th January and it was supposed to reach NLSIU on 15th January, but you took a flight on 14th January itself. You went to NLSIU and told them directly that you were rejecting their offer, then your revocation is complete because your revocation of your acceptance reached faster than your acceptance. Your acceptance reached on 15th Jan, but your revocation reached on 14th Jan itself. Okay. So with this background and a detailed recap, let's quickly discuss our today's topic. We'll discuss this interesting concept of lapse of an offer. Okay. Now, there's one basic rule which all of us should remember, which is that acceptance of an offer must be made before the offer lapses. Okay, so if NLSIU makes you an offer and tells you that we are offering you a seat at NLSIU, if you wish to study here, then you communicate your acceptance in 7 days. Then it is mandatory for you to communicate your acceptance within that 7-day window. If you don't do that, and let's say you communicate your acceptance on the 8th day, then your acceptance is not a valid acceptance because on the 8th day the offer had lapsed. Okay, so this is the basic rule which you should remember, that an offeree has to make the acceptance before the lapse of the offer. Now the question is, how does an offer lapse? How does an offer lapse? An offer can lapse in various ways, and we'll look at all of these one by one. Number one, by revocation. By revocation of the offer. Now, if I make you an offer saying, I want to sell my pen to you at ₹10, will you buy this pen? Let's say I don't hear from you for 15 minutes. Then I tell you that now I won't sell this to you. This offer no longer exists. That is called revocation or cancellation of my offer. Now I have cancelled my offer. Even if you tell me now that you want to buy, your acceptance is not binding. I will not be bound by your acceptance because my offer has already lapsed or has gotten cancelled. Okay, so offerer can revoke or cancel the offer. But then you might be thinking that there must be a timeline by which the offerer should get this prerogative of revoking his or her offer. Okay, so that timeline is, offerer has to communicate the revocation of offer before acceptance is made. In my pen example, if you had communicated your acceptance to me saying that you wanted to buy my pen at rupees 10 before I cancelled the offer, then I would have been bound by your acceptance. So the simple rule is, before acceptance is made, if the offerer cancels the offer, then the offer lapses. But once an acceptance has been made, then the offerer cannot revoke or cancel the offer. Okay. Now there are certain things which you should note here. We saw this, that offerer has to communicate the revocation of offer before acceptance is made. Okay. It means that revocation is effective, revocation of offer is effective only when it reaches the offeree. So that is the first requirement. Whenever an offerer has to revoke an offer, he has to communicate the revocation to the offeree. The offeree should get to know about that revocation. Okay? And second, revocation is effective only when, so again, revocation of an offer is effective only when it reaches the offeree before the acceptance is made. Let's understand the second point with the help of our postal rule example. NLSIU made you an offer on 13th Jan. You received it on 13th Jan. Okay. You posted your acceptance on 14th Jan. NLSIU tries to revoke the offer on 15th Jan. They send you a letter again on 15th Jan saying that we are cancelling the offer. Question: will NLSIU's revocation be effective in this case? You have to apply this principle. It says revocation of an offer is effective only when it reaches the offeree before the acceptance is made. In this case, when was the acceptance made? The acceptance was made on 14th January. Why? Because in postal rule of communication, we had clearly seen that acceptance is complete the moment acceptance is posted. You posted your acceptance on 14th Jan. Therefore, your acceptance was made on 14th Jan itself, even if NLSIU did not receive your acceptance on 14th Jan. The moment you posted it, acceptance is complete. NLSIU tried to revoke their offer on 15th Jan, which is after your acceptance was made. Therefore, this revocation by NLSIU is not effective because it was made after your acceptance was made. Okay. There's one more interesting scenario. Let's say NLSIU makes you an offer saying you can accept within 7 days. They are making you an offer to study at NLSIU and they have given you 7 days. Question: can NLSIU revoke their offer before the expiry of 7 days? Can NLSIU revoke their offer before 7 days, before the expiry of 7 days? And you might have come across this scenario. Let's say you clear any exam, or in case you clear it next year when you appear for CLAT. When you clear it, you will receive an email from NLSIU. They will say that we are holding this seat for 7 days. If you do not accept within 7 days, we will give it to somebody else. Okay, but if you do accept, then after that we will be in touch with you for the further formalities. So they have given you 7 days to accept their offer. Question is, if the offerer is clearly giving a predefined timeline to accept the offer, can the offerer revoke their offer before that timeline gets over? What if NLSIU, you think that okay, now you have cleared CLAT, you have gotten a seat at NLSIU, so you are extremely happy and you know that you have 7 days to accept their offer. But what if NLSIU sends you a communication on the 5th day saying that this offer no longer stands? And considering you had 7 days, you had not sent your acceptance by on the 5th day when the NLSIU's revocation came. Okay, question is, what will be the effect of NLSIU's revocation in this scenario? So let's write it down. NLSIU's offer made on 13th January. They give you 7 days to accept their offer. You have until 20th Jan to accept. On 17th Jan, NLSIU revokes their offer. Now, we clearly saw that an offer can be revoked. Sorry, these two conditions. Number one, revocation can be made. Revocation is effective when it reaches the offeree. So in the NLSIU example, the first condition is fulfilled because the revocation reached you. Second requirement for revocation of an offer is that it should be made. Revocation is effective only if it reaches the offeree before the acceptance is made. Okay, so we know that there are two conditions for revocation of offer. Number one, it should reach the offeree. This is getting fulfilled because NLSIU wrote to you, you received their revocation on 17th Jan. Second is, it should reach the offeree before the acceptance is made. So revocation has to reach before acceptance is made. This is also fulfilled because you have not conveyed your acceptance to NLSIU by 17th Jan. So their revocation reached first. Now you must be thinking this is quite strange because many a times when you get a time window to do something, you leave it until the last moment. Even in corporate life, you will see that if you receive an offer from a company, they will give you some time to accept the offer, and you also don't accept it right away. So if they give you 3 days to sign the offer letter, you would usually sign it on the 2nd day or the 3rd day. But the question is, what if they revoke their offer before you have signed? Based on what we discussed, it looks like the revocation will become effective, which means that in these scenarios, the acceptance should be given right away. If NLSIU gives you, even if NLSIU gives you a window of 7 days, ideally you should be accepting immediately. This is what must be going on in your mind. Okay, but there is one exception. Exception is when there is a consideration. It means that if the offerer makes an offer saying that the offeree has some time to accept the offer, and the offeree posts a consideration in exchange, then the offerer cannot revoke that offer before the timeline is complete. It simply means that in the NLSIU example, NLSIU gave you 7 days. Okay, and tells an NLSIU tells you that if you want us to lock your seat, then you make the payment of rupees 50,000 right away. Now, this is a consideration that has to be given by the offeree. Now, wherever there is any sort of consideration involved, okay, then the offerer cannot revoke the offer before the timeline is complete. Okay, then in this scenario, if you have paid 50,000 to NLSIU, they cannot revoke the offer before 21st Jan. You have until 28th Jan to accept. So NLSIU will be able to revoke their offer only after 20th Jan. Okay. Now there's one more interesting scenario, which is revocation of general offer. We saw that revocation has to be communicated to the offeree. Question is, how do you communicate revocation of a general offer? Because general offer is made to the world at large. Okay, there is no specific offeree in that scenario. So how do you communicate this revocation? The law says it can be revoked by the same mode by which it was made. Example, we had discussed the swimming example. One person made an offer in an advertisement, newspaper advertisement, saying that whoever crosses this river by swimming will get a prize money of 100 rupees. Okay, now the offer is open to anyone who fulfills this condition will get 100 rupees. Okay, now the offerer wants to revoke his offer. How does he do that? The law says he can revoke it by making a similar advertisement. So he can put out a similar advertisement saying that this offer is revoked, which means that he does not have to go and tell the entire world one by one specifically that this offer no longer exists. He just has to put out an advertisement in the newspaper saying that this offer is revoked. And let's say so there's a person A, when he saw the offer, he went to the river, and then he went to the river and he had made up in his mind that he is going to swim the river and then claim the prize money. But before he could get down in the river, this offer has been revoked. And this person A is not aware of the revocation. He did not see the revocation advertisement. Okay, and he swims across the river. After that, he gets to know that the offer has been revoked. Will A be able to claim the prize money? The answer is no, because this general offer was revoked before it was accepted. Again, that acceptance condition remains the same. Any offer can be revoked only before acceptance is made. So had A completed the condition was to swim across the river. Had A swam across the river before the revocation of general offer, then A would have been entitled to claim the prize money. Okay, but the moment a general offer is revoked, after that, if the offeree even if the offeree performs the condition of the general offer, the offeree will not be entitled to the prize money, okay, or whatever that offerer had offered. All right, so this is the first condition through which an offer can be lapsed. So we were discussing lapse of an offer. We saw that an offer can lapse through revocation by the offerer, revocation of the offer by the offerer. An offer can also lapse by time, which means that it is quite simple. It means that if the offerer has given you a specific time to accept the offer and you don't accept it within that time, then the offer lapses automatically. NLSIU example, If NLSIU gives you time until 20th Jan to accept their offer and you don't accept, then the offer automatically lapses on 21st January. Okay. If no time is mentioned in the offer, if no time is mentioned in the offer, then what happens? Suppose the offerer does not tell you the time within which you have to accept their offer. The law says if there is no time, then acceptance should be given in a reasonable time. Acceptance should be given in a reasonable time. Take the vegetable market example. You go to the vegetable market, you ask the shopkeeper, you offer the shopkeeper that I want to buy your potatoes at 50 rupees per kg. Will you sell your potatoes to me? The shopkeeper does not respond for the next 10 minutes. So you go to the other shopkeeper and then you purchase potatoes from the other shopkeeper. Now the first shopkeeper comes back to you and tells you that he accepts your offer. Question: will you be bound by his acceptance? Now apply this rule. In your offer, did you mention any specific timeline within which the shopkeeper had to accept? No. The law says if that is the scenario, then acceptance should be given in a reasonable time. Now, what is a reasonable time? A reasonable time needs to be ascertained based on the facts of the case. Now, in this scenario, in a vegetable market, you cannot be expected to wait for the shopkeeper's acceptance for 10 minutes or 15 minutes. In this scenario, a reasonable time would be a few seconds to a few minutes. Okay. So if you decided to go ahead with the other shopkeeper, that is completely fine. The first shopkeeper, if he comes back to you after 10 minutes, this is not a valid acceptance because he did not communicate his acceptance in a reasonable time. All right. Remember this, that if no time is mentioned in the offer, then acceptance has to be given in a reasonable time. Reasonable time is subjective. It will need to be determined based on the facts of the case. Third, how does an offer lapse? Third way is failure to fulfill a condition precedent. What is the meaning of condition precedent? Simply means that there is some condition that you need to fulfill before you can accept the offer. So if I offer to sell my pen to you at rupees 10, but my condition is that you will have to come to my home and accept my offer. Let's say you accept, you call me, on phone and you accept my offer. What happens then? You will have to apply this rule. There was a condition precedent. What was the condition precedent in my offer? The condition was that you will have to come to my home and accept the offer. Did you do that? You did not do that. If you did not do that, then my offer lapsed. Okay? The moment you called me and told me that you were accepting my offer lapsed at that moment itself because you did not follow the condition which I had prescribed in my offer. Fourth way in which an offer can lapse is by death or insanity of the offerer. So after the offerer makes you an offer, let's say the offerer dies or becomes insane, becomes mad, then the offer lapses. There is only one exception or condition: knowledge of the death or insanity of the offerer should be with the offeree before communicating his acceptance. So it simply means that before the offeree accepted the offer, he should be aware of the fact that the offerer has died or has become insane. Okay, let's understand this with the help of an example. My example only. I offer to sell you my pen at rupees 10. But before you could communicate your acceptance to me, you got to know that I have died. In this scenario, the moment you got to know that I have died, and let's say by that time you have not communicated your acceptance, you've not given your acceptance, then this offer lapses. But what happens if you have given your acceptance without being aware of the fact that I have died or I have become insane? What happens in that scenario? The law says that if the offeree has given the acceptance and while giving acceptance he was not aware of the death or insanity of the offerer. In this scenario, acceptance is valid. Then your follow up question, acceptance is valid, which means that agreement is concluded. Now you must be thinking, if the person has already died or become insane, now this agreement will be binding on whom? The short answer is on the legal heirs of the offerer, and we will understand the concept of legal heirs when we discuss family law. Okay, but for now just understand that if the offeree had knowledge of the death or insanity of the offerer before giving acceptance, then this offer lapses. But if the offeree did not have knowledge of the death or insanity of the offerer at the time of giving acceptance, then the acceptance is valid, and therefore there is a valid agreement. All right. Okay, it has become a very lengthy class today, so go and revise all these things. Tomorrow we will discuss, like today we discussed lapse of offer, and while discussing lapse of offer, we saw that one of the ways in which an offer can lapse is by revocation of offer. So tomorrow we are going to see how an acceptance can be revoked. So today we saw how an offer can be revoked. Tomorrow we will talk about the manner in which an acceptance can be revoked. Okay, all right, thank you.